What happens when a therapist knows that their patient may harm someone? Should confidentiality always come first? Or is there a point where protecting a life becomes more important than protecting a secret? Welcome back to Headspace Diaries. I am your host Malavika, and in today's episode, we are exploring one of the most influential legal cases in the history of psychology and mental health ethics, Tarasoff versus Regents of the University of California. This landmark case forever changed the responsibilities of psychologists, psychiatrists, and other mental health professionals by introducing the concept of the duty to warn and duty to protect. We'll unpack the tragic events that led to the case, examine the legal battle that followed, and discuss how its impact continues to shape clinical practice and ethical decision making around the world. Whether you're a psychology student, a mental health professional, or simply fascinated by the intersection of law, ethics, and human behavior, this is an episode you won't want to miss. Trust me. So sit back, grab your headphones, and let's dive into the story behind one of psychology's most important legal precedents, Tarasoff versus Regents of the University of California. The question posed in front of the California Supreme Court is this. Say you're a psychologist. A patient tells you with chilling specificity that he plans to kill a woman he names. You believe him. You call the campus police and they briefly detain the patient. Your supervisor orders the case closed and the records destroyed. The woman returns from a trip abroad, unaware of any danger. 2 months later, she's dead. Her parents sue. Did the psychologist have a duty to warn her? This is the story of Tatiana Tarasoff, who was a real person, a college student, and a daughter. She was a student at the University of California, Berkeley, known as Tanya to her friends and family. She met Prasenjit Podar, a graduate student from Bengal, India, in the fall of 1968 at folk dance lessons in the International House where he resided. Little did she know that this meeting would change her life forever. The story goes that they saw each other about once a week until New Year's Eve when she kissed him, but he misinterpreted that kiss. He believed it to symbolize the seriousness of their relationship, which he explained to Tanya, who rejected this. She said that he was wrong and that she was more interested in others than in him. So here we see that this is a very normal and casual dating situation in the US. Often, in the early talking stages of a relationship, it's common to find young people go on multiple dates with multiple different prospects. But in India, this is not so. And at least it wasn't so in 1968. Podar entirely misunderstood the situation. And even when Tanya cleared it up by firmly stating that she wasn't interested in him, he chose to disregard the evidence and pursue her. In psychology, we call what Podar had a delusion of love. Due to this rejection, Podar underwent severe emotional crisis where he became withdrawn. He ignored his studies, stayed alone often, and wept frequently. He had occasional meetings with Tarasoff, and he secretly tape-recorded their conversations in an attempt to discover why she did not love him. Oh my God. So he began to visit a campus psychologist, Dr. Lawrence Moore, who worked in the Cowell Memorial Hospital. My guess is that he started noticing that he himself was becoming obsessed with this girl, and he realized it, and I think that some part of him wanted to change himself for the better, and so he started visiting the psychologist. Now, sometime later in the summer, while Tanya was on a vacation to Brazil, he confided to Mo that when she returned, he was going to kill her. The psychologist believed him, notified the campus police, and requested that he be detained. So far, the psychologist followed all protocols and did the right thing ethically. And Podar was detained for a short time, but he was released by officers Atkinson, Brownrigg, and Halloran because he appeared rational and promised to stay away from her. I believe in this case, the police too had a role in Tanya's death because they completely dismissed the clinical findings of a mental health professional and released Podar based on their subjective judgment of rationality. So Podar then terminated therapy due to Moore's attempts to hospitalize him, and upon the order of Moore's superior, Dr. Harvey Powelson, who was a psychiatrist, no further steps were taken to commit him or warn Tanya. And he then ordered that all the copies of Moore's letter and therapy notes be destroyed. Podar persuaded Tatiana's brother afterwards to share an apartment with him near Tatiana's residence. And this could not have any good outcomes. I don't foresee any good outcomes from this alliance with Tatiana's brother. But anyway, shortly after this alliance and shortly after residing with Tatiana's brother, on October 27th, 1969, Podar went to Tanya's home to talk with her. Again, I don't see any good omens here. So she was not at home and her mother told him to leave. He did, but he returned later that night with a pellet gun and a butcher knife. He said he wanted to speak with her and she began to scream. He then shot her with the pellet gun and she ran from the house. Podar followed and catching her, he stabbed her repeatedly and fatally with the butcher knife. So, what went wrong here? I mean, from the perspective of a psychologist, what was the failure from the employees of the University of California? Well, we see a failure to detain a dangerous patient, a failure to warn about the dangerous patient, an abandonment of the dangerous patient, and breach of the primary duty to patient and the public. So what followed was a legal battle between Tatiana's parents and Moore along with Dr. Powelson, the campus police, and their employer, the University of California. It is said that the Alameda County Superior Court dismissed the Tarasoff's complaint, after which they proceeded to the California Court of Appeal, but to no avail. Finally, they approached the California Supreme Court. While Podar was convicted of second-degree murder, but the conviction was actually overturned on the grounds that the jury had been inadequately instructed, and Podar was released on the condition that he returned to India. The university, on the other hand, and its counseling center became involved in a lengthy civil litigation. Universities, hospitals, and mental health professionals across California had to revise their policies regarding confidentiality and warning potential victims. So here, the defendants, that is the Regents of the University of California, their case was that they had no relationship with Tatiana whatsoever. And they had a relationship with Podar, and they did not find it necessary to warn Tatiana. So after this, that is the Tarasoff ruling, as we call it, all the mental health professionals and counseling centers, everyone had to revise their policies to add this duty to warn and duty to protect. Now, what happened is, so the court actually issued two opinions in this case. So the first was in 1974, commonly called Tarasoff 1, focused narrowly on a duty to warn the intended victim. But then the court granted a rehearing and issued a revised opinion in 1976, which is the Tarasoff 2, that broadened the standard to a duty to protect. And this distinction matters because warning the victim is only one way a therapist can satisfy the obligation. The final ruling made clear that therapists could fulfill their duty through whatever steps are reasonably necessary given the circumstances, including notifying the police, seeking involuntary commitment of the patient, or intensifying treatment. However, not everyone was satisfied with this ruling. So before you judge that person to be evil, let's hear him out. Justice William Clark dissented, arguing that the ruling would discourage people with violent impulses from seeking therapy in the first place. His concern was straightforward. If patients know their therapists might disclose what they say, they'll either avoid treatment entirely or withhold the most dangerous thoughts. That means therapists lose the ability to intervene before violence happens. So this dissent viewed the majority opinion as a well-intentioned policy that would paradoxically make the public less safe by driving dangerous individuals away from the treatment that could prevent violence. So what can be done here? Let's understand the specification of this duty to protect more clearly. It only applies in situations where there is a serious threat of physical violence, which is specific and not vague hostility, and when there is a reasonable, identifiable victim. So a patient who says, "I'm so angry I could hurt someone," does not trigger this duty unless they specify the means or an identifiable victim. Some states have actually expanded on this duty to threats to property or threats of committing any criminal act. And no, in such cases, for breaching confidentiality, the therapists will have immunity from being sued. So when a therapist believes that directly warning the potential victim could actually increase the danger, the therapist can choose an alternative protective action instead. Good documentation of the reasoning behind that choice is critical, however, and if the decision is ever challenged, a court will look at whether the therapist's judgment was reasonable and whether the record reflects a thoughtful risk assessment rather than inaction. So, as we wrap up today's episode, the story of Tarasoff versus the Regents of the University of California reminds us that some of the most important legal cases aren't just about what happened in a courtroom. They're about the difficult choices professionals face when ethics and safety collide. Should a therapist always protect a patient's confidentiality? Or are there moments when protecting a potential victim must come first? The Tarasoff case forever changed how mental health professionals approach that question. It established the principle that when there is a serious foreseeable threat to an identifiable person, the duty to protect life may outweigh the duty to keep a patient's confidence. Today, the duty to warn, duty to protect continues to shape laws, professional ethics, and clinical practice around the world. So while the exact legal requirements vary by country and jurisdiction, the conversations sparked by this case remain just as relevant as they were decades ago. So before we end, I'd like to acknowledge that this episode discusses a real tragedy involving real people. At the heart of this landmark was Tatiana Tarasoff, a young woman whose life was taken far too soon. We encourage everyone to remember that behind every legal precedent and psychology textbook is a human story. So as you discuss or study this case, please do so with empathy, respect, and compassion for Tatiana, for her family, and for everyone whose lives were forever changed by these events. Thank you for listening to this episode. If you found it insightful, don't forget to follow the podcast and share this podcast with friends or classmates and leave a rating or review. It really helps us reach more listeners. And we'd also love to hear your thoughts. Do you think the court made the right decision? And where do you believe the line should be drawn between confidentiality and public safety? So until next time, stay curious, keep questioning, and remember, understanding the past helps us make better decisions for the future.